There was a power issue. So I've logged in from different account now. Just a minute. So let me share it again. I was at section 3. Let me share. Okay. So section 3. We were at section 3. I hope I am audible. Am I
Sir.
audible?
Yes, sir.
Okay, okay. So section 3. So in section 3, let us see some of the important definitions. Rest you can cover. So now first is the definition of claim. In claim, there is a right to payment. That means you have done some work or you have given some money. When you get the right to payment, either you have given some money, then you have the right to get it back, or you have rendered some
Services.
services, or you have supplied some goods, or there is some statutory liability. So all these are covered under right to payment. It could be, it may or may not be reduced to judgment. It may be fixed, may be disputed, undisputed, legal, equitable, secured or unsecured. So if you have got a right to payment, that means it is covered under claim. Second is, there is no direct right to payment, but you have got the right to remedy for breach of contract under any law for the time being in force if such breach gives rise to right to payment. So directly you are not entitled for payment, but you have got a remedy. You have got a right to remedy for breach of contract. So if the other party commits a breach, then you have covered, then you have got a right to payment. This is the meaning. So there could be cases where, just a minute. Okay. So there could be cases where you are, say, constructing a contract, you are constructing a project, and there are some obligations and counter obligations. And if the other party does not perform its part of the obligations, then you have got a right to remedy for breach of contract. Like I normally give the example of free supply of steel and cement. So you are a contractor, but the client is obliged to give you free supply of cement and steel. And if it doesn't give you and it results in delay, then you are entitled for some damages. So that will be covered under claim. This is the meaning. Another important thing is there is a difference. Two terms are used. One is corporate person and the other is corporate debtor. So can anybody tell me what is the difference between corporate person and corporate debtor in the context of IBC? What is the difference? Corporate person and corporate debtor. Anyone? Pooja ji, what is the difference between corporate person and corporate debtor? Or they are
But the
one and the same thing?
corporate person may or may not be owing any debt to
Right. Very
any
correct.
person.
Very correct.
But a corporate debtor is one who owes a debt to another.
Right. So there could be a situation why they are using two terms. There is a case of voluntary liquidation also. So voluntary liquidation is also one of the processes which is covered under IBC. So in case of this voluntary liquidation, it could be a debt-free company and still it could go in for voluntary liquidation. So corporate debtor is the term which they have reserved for corporate persons who are under some obligation, who have incurred a debt, basically. And corporate person, what is not included in corporate person is a financial service provider. Because these corporate persons, they are covered under chapter 2. Why they are not including the term financial service provider? Because for financial service providers, there is a separate section, section 227. Section 227 talks of a scenario where a financial service provider could also be brought within the ambit of IBC. Normally, suppose bank has given you loan and you don't pay, bank can initiate proceedings under IBC against you. But suppose you have rendered services to the bank and banker doesn't pay, then whether you have right to initiate proceedings against the bank, yes or no?
That it will be subject to approval of the regulator.
Right. So there is a separate procedure. Procedure is similar, but because different regulator is involved. RBI is the regulator which is regulating the financial service providers. So the central government will get in touch with that regulator and then they will issue a notification. If at all that financial service provider is to be brought within the ambit of and this IBC. So corporate debtor means a corporate person who owes a debt to any person. So corporate person and corporate debtor, they are two different things. Another important definition is of debt. So debt means a liability or obligation in respect of a claim which is due from any person and includes a financial debt and operational debt. So they have made a distinction between claim and debt. So debt they are saying liability or obligation in respect of a claim which is due. So there could be a claim which may or may not be due. Suppose you are a construction contractor, you are executing project on behalf of a client, you may not be entitled for billing because billing is subject to achievement of certain milestones. Now suppose there is a stoppage in between. The company stops its operations. There is some unbilled amount. So whether you are entitled to claim that amount, the answer is yes. But whether it is covered under debt, the answer is no. Because it is an uncrystallized liability, unliquidated amount. There is a concept of unliquidated amount also. So they say debt means a liability or obligation in respect of a claim which is due from any person and includes a financial debt and operational debt. And here in IBC, only those which are having some financial debt or operational debt, only they can initiate the IBC proceedings. And then default also. So default means non-payment of debt when the whole or any part of the installment of the amount of debt has become due and payable and is not paid by the debtor or the corporate debtor, as the case may be. So why they have used the word debtor and corporate debtor both? Any idea? Why they have used the word debtor or corporate debtor here? In 12. Puja ji, they should have written only one word. Why they've used the word debtor or corporate debtor? It is because section 3 applies to whole of the code. And this debtor could be an individual also. So, because even part 3 is covered, so section 3 contains definitions which apply to the whole of the code. So debtor could be an individual also, it could be a partnership firm, or it could be a corporate person who has incurred a debt and there is a default. So in corporate debtor, you will be covering whom? So there could be a case where the corporate debtor is owing a debt, but that is not under default. Okay? So who can initiate proceedings? First of all, there has to be debt and that debt has to be due and there has to be default. That means non-payment of debt. Only then you can initiate proceedings. Now section 4 talks of the trigger point. The trigger point is the rest of the definitions we will cover through section wise jurisprudence. So section 4 talks of the triggering point. And what is the triggering point? The triggering point is
Default.
right, default. So there has to be a default. Minimum amount of default is 1 lakh and the government has reserved its right to increase it by a value not more than 1 crore and they have exercised this option. Okay. And in respect of prepack, the minimum amount of default is 10 lakh rupees.
10.
So, and this prepack process is restricted to corporate MSMEs only. So basically, there are 3 types of insolvency resolution for corporate persons. What are they? One is normal CIRP, second is fast track CIRP, and third is prepack process. So these are the 3 processes aimed at insolvency resolution of corporate persons when they have incurred a default. Now, in case of prepack, the minimum amount of default is 10 lakh rupees.
Yeah.
Now, suppose there is an MSME which has incurred a default of say 200 lakhs. Whether it can go in for normal CIRP or it has to go only through PPIRP. I hope you have understood my question. My question is, because what we have read is, we have read that pre-pack insolvency resolution process, which allows the debtor to stay in control and which allows the corporate MSME to initiate this process of insolvency resolution, there the minimum amount of default is 10 lakh rupees. But that is the minimum. Maximum could be anything. Suppose the maximum, the actual amount of default is 200 lakhs or say 2 crores. My question is whether it can go in for normal CIRP or it has to necessarily go through PPIRP. This is the question.
So normal CIRP?
Right. Normal CIRP is also possible. So in that company has the option, that corporate MSME has the option either to go in for prepack or for normalcy.
Yeah.
So both the options are available. But suppose the amount of default is 50 lakhs, then it cannot go in for normal CIRP because for normal CIRP, it is 1 crore.
1 crore.
So both for normal CIRP and this fast track process also, the amount of default is 1 crore.
So, sir, sorry, sir, to disturb, but
Yes.
so what exactly we need to conclude over here is that if the default in case of this MSME exceeds 1 crore, that threshold limit of 1 crore that is applicable for corporate person, then they have that option whether they want to go.
No. Actually, it says here in case of prepack, they say that the central government shall by notification specify minimum amount and that minimum amount cannot exceed 1 crore. But then they issued a notification and by virtue of that notification, they said that the prepack amount shall be 10 lakhs. So minimum amount they have specified by way of notification is 10 lakh. Now there are two limits. One is 1 crore, another is 10 lakh. My question was because this is the minimum amount in case of prepack. So in case of corporate MSMEs, which only have the right to go in for this prepack insolvency resolution process, the minimum amount is 10 lakhs. Now, suppose the actual default is say 200 lakhs or 2 crores. So my question is whether that corporate MSME can go in for CIRP or normal CIRP as we call it. The answer is yes. Because minimum amount has been given, maximum there is no limit. But suppose there is a company in which the default amount is say 50 lakhs, but it is not a corporate MSME. Then what is the option available?
PPIRP only.
No, it is not a MSME. It is
Achha.
not a corporate MSME. There is a company which is not a
MSME.
corporate MSME, right? The amount of default is 50 lakhs. Now, what are the options available with the financial creditor? Suppose you have given loan to a company. Now, that company is not a MSME, corporate MSME. Amount of default is 50 lakhs. Then what are the options available? You want to recover the money, company is not paying you the money. Then what are the options available?
Sir, under IBC, they cannot go. They can go in for SURFACE Act under. If there is a secured creditor.
Right. If it is a secured creditor, they can take action under SURFACE. If it is a bank or financial institution, they can go into DRT or they can go to civil courts or commercial courts or other forums, whatever are available. But for this IBC, minimum amount of default is 1 crore rupees, except in case of corporate MSMEs, where the amount of default is 10 lakhs. But in case of corporate MSMEs, there is another restriction. The restriction is that only the corporate person, only the corporate debtor can go in for this pre-pack process. The creditors cannot go in for this process. That is another restriction about which we will read in detail later. Now section 5. Section 5 talks of another important definition that Vinayji, now it is clear, I think.
Yes, sir. Yes, sir.
Okay. So section 5. Section 5 also contains some of the important definitions. One of the very important definitions is of dispute. And it says dispute includes a suit or arbitration proceeding relating to the existence of the amount of debt, the quality of goods or service, or the breach of a representation or warranty. Now, what is the logic behind reading this definition of dispute? Why we are reading this definition of dispute?
Sir, it is basically, if there is a dispute and because of the dispute, the person has not paid the amount, and that is why the default has not crystallized because of the non-resolution of the dispute. For
Right,
example, you have supplied goods which are of inferior quality,
right,
and the company has raised objections.
right.
So the dispute is with regard to not, there is a breach of terms and conditions, and there is a difference with regard to non-payment of the
Mhm.
amount.
The point here is that IBC is not a recovery mechanism. So they say if there is a dispute, then you cannot go in for this process. You have to go to other forums. So that is the point. So in case of dispute, application by operational creditor cannot be initiated. But is it so in case of financial creditor also? Suppose a banker has given a loan and there is a dispute. Then in that case, whether the banker can file an application under section 7? Yes or no?
Yes, sir.
Yes. So the question of dispute is not relevant in case of financial debt. It is relevant only in case of operational debt. Why? Because in case of operational debt, it is not a recovery mechanism. But then why can't you apply the same logic to financial debt? They say there is a difference between financial debt and operational debt. They say that the financial creditors are the one who have provided financial muscle to the company. So they have funded the organization. So they are the persons who are entitled to claw back the control from the management in case there is a default. But operational creditors, they have not funded the organization. They may come and go. There could be 200 suppliers, 300 suppliers, but normally the financial creditors stay with the company for a longer duration. Normally, they stay invested in the company. So financial creditors have given an edge in IBC. In say decision making process also, which is governed by a committee of creditors. Normally, operational creditors will not find place in the committee of creditors unless they form a substantial portion or unless they are the only creditors. Suppose there are no financial creditors. Suppose it is a debt-free company. Suppose there is no financial debt, but only operational debt is there. So then they will constitute the COC. But in normal circumstances, only the financial creditors will come in the COC. Another important definition is of insolvency resolution process cost. So what is the significance of this insolvency resolution process cost? Anyone? What is the significance? Why it is important to understand this definition? Insolvency resolution process cost. Anyone? Why it is important?
So to just have an idea of what exactly would be the cost involved for completion of the insolvency proceedings, and this amount has to be approved by the COC.
Actually, this insolvency resolution process cost basically comprises of 2-3 things. Number one, the cost incurred during running the company during the CIRP period, because First of all, we have to try to resolve the economic obstacles which the company is facing, the financial crunch which the company is facing. So they say, because we have to keep the show running, so naturally there may be some costs, there may be some supply of materials, some wages may be required to be paid to the employees or workers. You have to have an insolvency professional who will overlook the process, because the management, powers of the management, powers of the board stand suspended. So naturally, the insolvency resolution professional has to be paid his fees. So there are certain fees which have to be paid in priority to other payments like financial debts or operational debts. So before any financial creditor or operational creditor is paid, what has to be paid first is covered under the insolvency resolution process cost. So it covers the cost of running the enterprise during this process, insolvency resolution process period. It could be the cost of, say, interim finance. It could be the cost of supply of goods or services. It could be the rent. It could be wages payable during this period. And then the fees of the insolvency professional. So this insolvency resolution process cost gets a priority over any other dues. So before any financial debt or operational debt is paid, first of all, this cost has to be paid. Okay? So that is why it is important. Similar is the liquidation cost. So liquidation cost is the cost incurred during liquidation process. And that is the fees payable to the liquidator, amount incurred for keeping it as a going concern during liquidation also, because in some situations it could be kept as a going concern also if the stakeholders consultation committee decides so. And similar is the definition of prepackaged insolvency cost, insolvency resolution process cost. So all these definitions are similar. Related party is very important concept in case of this corporate data. So it says, first of all, we have to see whether this corporate debtor, definition of corporate debtor we have seen. The definition of corporate debtor is a person. Corporate debtor is a corporate person who owes a debt to any person, right? This definition we have seen. Now, this corporate debtor may have entered into transactions with two types of parties. There could be unrelated parties. There could be related parties. Why understanding the definition of related party is important? Why it is important? Because there may be a tendency to divert the funds to some related parties. Say, because the management was aware that there could be some issues, financial issues, so they diverted the funds to the related party. So there is a concept of look back period, that what are the transactions they have entered into with a related party, say during past 2 years. So that is one of the aspects. Another important thing is whether during CIRP they can enter into transactions with related parties. There is no bar, but approval of the committee of creditors has to be taken for transactions with related parties. So related party is very important from various angles. Number one, the decisions during insolvency resolution process period have to be taken by a committee of creditors. And committee of creditors is normally consisting of financial creditors. I have given you the logic. So there is a intelligible differentia between financial creditors and operational creditors. Financial creditors can initiate the process even despite default, but even despite dispute. But operational creditors cannot initiate this process if there is a dispute. This is one distinction. Then normally financial creditors find a place in the committee of creditors. But whether related parties, suppose your director has given a loan to the company, so whether he will find a place in the COC, the answer is no. So related parties, they do not find a place in the COC. Because why? Because they are related to the management. It could be a personal relationship. It could be a professional relationship. they have the ability to influence the decisions. It may be by way of, say, voting share. It may be by virtue of some ability to control or appoint majority of directors, or ability to terminate the directors. So these could be some of the instances of related parties. Then related party in relation to an individual. Why it is important? Because of part 3. Because IBC deals with insolvency process of individuals and partnership firms also. So related party has to be seen in that context also. Okay. So these are some of the definitions. And section 6 talks of persons who may initiate this process. So it says where any corporate debtor commits a default. Now you understand why they have not written the word corporate person here. Because only corporate debtor will commit the default. Corporate person could be a person who has not incurred any debt. So corporate debtor is a person who has taken a loan, who has incurred a debt, and when he commits a default, so the triggering point is default. Who can file the application? Financial creditor, operational creditor, or the corporate debtor itself may initiate corporate insolvency resolution process in respect of such corporate debtor in the manner as provided under this chapter. So this is brief about sections 1 to 6. Now let us see section wise jurisprudence on the various issues which were involved in section 1 to 6, because that will help us in understanding section 1 to 6 in a better perspective before we move to section 7. Section 7 we'll take up in the next class, but let us see the section wise jurisprudence on sections 1 to 6. So this is section wise jurisprudence. What it says, it's an IBBI publication and it has been updated by Pooja Vasudeva ji. So we are thankful to her for this. Section first case, let us see this case, and it relates to objective of the code. The case is Swiss ribbons, and the cases which we have highlighted in green, they are in our syllabus also. So side by side, we will be having a grip over the syllabus wise case laws also, because 72 case laws are in our syllabus. So Swiss ribbons is the case in which they said that the code is a beneficial legislation. So for whose benefit the code has been enacted? Whether for the benefit of creditors or for the benefit of corporate debtors? Yes, any idea?
To enable the corporate debtor, or the
Right. So it is a beneficial legislation for the corporate debtors or other individuals and partnership firms. Why? Because suppose there are two fallouts. Suppose a company is not able to pay, then what will happen ultimately? Either it could be sold to some other person by way of a resolution plan, or there could be a liquidation. So in case of liquidation, what will happen? There will be unemployment because the employees will be terminated. So they say that if resolution is done, then it is better. It is better for everyone. The code is a beneficial legislation which puts the CD back on its feet and is not a mere recovery legislation for creditors. So that is the reason why operational creditors are not allowed to file petition for insolvency in case there is a dispute. Why? Because it is not a recovery mechanism. Okay. The interests of the CD have therefore been bifurcated and separated from that of its promoters, those who are in management. So there is a difference. Okay. The defaulter's paradise is lost. In its place, the economy's rightful position has been regained. Now, in innovative industries, this is also in our syllabus, what the Supreme Court said. Supreme Court said that one of the important objectives of the code is to bring the insolvency law in India under a single unified umbrella with the objective of speeding up the insolvency process. In Prowess International, Now, this is not in our syllabus, but still, we should read all these cases to have a better understanding of the code. And these are the cases on objective of the code. So in this case, what was held? CIRP is not a recovery proceeding. To recover the dues of the creditors, the code is an act relating to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals in a time-bound manner for maximization of value of assets of such persons and to promote entrepreneurship, availability of credit, and balance the interest of all the stakeholders, including the government dues. So it is some sort of reproduction of the preamble. Okay. In DF Dosh forfeit AG and another versus Uttam Galwa, what was held? It was held that to get conversion to new law and to see fruits of it, it will take time. But just for the sake of this reason, we cannot wish away the mandate of this nation which has come through Parliament. Then the State Bank officer versus Rainbow Papers. This is also an important judgment. And it says, in view of statement of objects and reasons of the code, read with section 53, the government cannot claim first charge over the property of the CD. So it said that the government cannot claim first charge over the property of the CD. Okay. Then in V Hotels versus Asset Reconstruction Company, it was said what is sought to be achieved in the code is not shutting down of the CD, but reviving it. So what is the idea? Not to shut it down, but to revive it by ousting the defaulter promoter directors who were in control and management of the CD. So they say, let it be handled by a regulated private professional, because this insolvency professional is not a government officer. He is a regulated private insolvency professional. The object of the code is no doubt to protect the genuine CD with a view to maximize its value of assets and find out a resolution plan to revive the CD. Okay. The proceedings under the code are independent and have an object different from the one envisaged under the scheme of liquidation provided in the company law. Because in company law also there are provisions regarding liquidation. But here the objectives are different. The former aims for resolution by way of revival in a manner that benefits all stakeholders, the creditors as well as the CD. Then Kridhan Infrastructure Private Limited, it was said that time is crucial facet of scheme under the code, and to allow such proceedings to lapse into an indefinite delay will plainly defeat the objective of the code, because it is expected to be a time-bound mechanism. What was the defect with the earlier laws? Suppose winding up cases were being handled by high courts there. So it took them decades before the cases were disposed of. But here they say whatever you want to do, you do it in a time-bound manner. Then another case, K.N. Rajkumar, one of the principal objects of the code is providing for revival of the CD and to make it a going concern. Every attempt has to be first made to revive the concern and make it a going concern, liquidation being the last resort. Okay. Next case, an objective of the code is to free up resources of unviable companies by permitting an easy exit. Okay. It cannot be misconstrued to keep unviable units afloat by some sleight of hand under the guise of keeping it as a going concern, thereby defeating a key objective of the code. So they say, if you are ultimately unable to run the company, if there are no takers, then that simplified exit should also be there. Okay. So one of the objective of the code is to conduct the CIRP in a time-bound manner, therefore to save the time. Upon coming to the knowledge of the admission of the CD into CIRP, the statutory authorities should withdraw their direction of attachment of the assets of the CD. So there could be directions regarding attachment. So they also have to withdraw their directions in case the company goes into CIRP, about which we will read in detail in the concept of moratorium. So this was on object of the code. Now let us see section 2. So section 2E, because in section 2E, what they have done is they have made a distinction, because what we have read in the preamble, we have read that it is applicable not only to companies but individuals also, individuals and partnership firms. Now by section 2E, they made a distinction between individuals and partnership firms. So there could be some individuals or partnership firms who have taken the loan on their own. Second could be the case where individuals or partnership firms have given a guarantee to a corporate person. Now what they have done is they have made the provisions applicable only, they have issued the notification in respect of individuals and partnership firms who have given a guarantee. So personal guarantors and corporate guarantors, so they are covered. So section 2E, which was brought into force on 23rd 11/2017, would, when it refers to the application of the code to a personal guarantor of a CD, applies only for the limited purpose contained in subsection 2 and 3 of section 60. This is what is meant by strengthening the CIRP in the statement of objects and reasons of the IBC code. So this is the case which is covered in your syllabus also, State Bank of India versus Ramakrishnan. So what the Supreme Court said? Supreme Court said that it provides strength to the CIRP process. So by making the provisions of IBC applicable to personal guarantors to corporate debtors, so they have provided strength to the CIRP process. Suppose the company is not having any assets, then where from the money will come? Although we say that it is not a recovery mechanism, but the financial creditors or the operational creditors, they are entitled to their claims. They are entitled to the money or the, say, compensation for goods or services they have supplied to the company. So it says that unless we make personal guarantors also accountable side by side with the company, then only the whole objective will be achieved. ठीक है? अदरवाइज क्या होगा? मान लो पर्सनल गारंटर्स को एप्लीकेबल नहीं किया तो कंपनी के पास कुछ है नहीं, फिर कहां जाएंगे फाइनेंशियल क्रेडिटर ऑपरेशनल? तो यही पर्पस है इसका. Next is on section 3. On section 3, there are a lot of cases. First is the CD cannot use the provisions of section 3 as a blanket cover to claim exclusion from proceedings under the code on the ground that it is a financial service provider. ठीक है? तो वो कहता है कि भाई ऐसा है कि इफ इट इज ए फाइनेंशियल सर्विस प्रोवाइडर ओनली, ठीक है, तो उस केस में इट कैनॉट क्लेम एक्सक्लूजन फ्रॉम प्रोसीडिंग्स अंडर द कोड. ये मतलब. देन ऑन क्लेम वी हैव ऑलरेडी रेड दैट क्लेम मींस राइट टू पेमेंट और राइट टू रेमेडी फॉर ब्रीच ऑफ कॉन्ट्रैक्ट विच गिव्स राइज टू राइट टू पेमेंट. ये हमने पढ़ लिया. अब क्लेम के ऊपर बहुत सारे केस लॉज हैं. क्या क्या कहते हैं? सबसे पहला तो ये कहता है कि क्लेम अंडर सेक्शन 3 सबसेक्शन 6 मींस अ राइट टू पेमेंट इवन इफ इट इज डिस्प्यूटेड. तो डिस्प्यूटेड होगा तो भी क्लेम तो है ही है. ठीक है. नेक्स्ट है स्विस रिबन्स. स्विस रिबन्स में क्या कहा? क्लेम गिव्स राइज टू डेट ओनली when it is due and default occurs only when debt becomes due and payable and is not paid by the debtor. ठीक है. उसने क्या कहा कि claims gives rise to debt only when it is due. तो every claim is not a debt. Claim debt कब बनेगा? When it is due. और default कब होगा? जब debt due हो गया और payment नहीं हुआ, तब वो default. ठीक है. The different claims arising out of different agreements or work orders having different amount and different dates of default cannot be clubbed together for alleged default of debt as the cause of action is separate. ये केस क्या था? वो ये कहता है कि suppose a company has awarded say 5 contracts. ठीक है. अब आप उनको you cannot club them together. ठीक है. क्योंकि क्या है? अमाउंट डिफरेंट है और डिफरेंट डेट्स ऑफ डिफॉल्ट है. सो यू कैनॉट क्लब टुगेदर फॉर एलेज डिफॉल्ट ऑफ डेट एज द कॉज ऑफ एक्शन इज सेपरेट। एक कंपनी ने 5 प्रोजेक्ट्स दे रखे हैं, कोई दिल्ली में, बंबई में, गोवा में, इस तरह से, ठीक है। तो हर एक जो कॉन्ट्रैक्ट है वो सेपरेट कॉज ऑफ एक्शन है, आप उनको क्लब नहीं कर सकते फॉर द पर्पज ऑफ इनिशिएटिंग दिस प्रोसेस, मतलब ये है, ठीक है। नेक्स्ट इज द ट्राइब्यूनल कैनॉट गो इनटू रोविंग इंक्वायरी इनटू द डिस्प्यूटेड क्लेम ऑफ पार्टीज। भाई हमने क्या कहा, हमने ये कहा कि अगर डिस्प्यूट है, ठीक है, तो फिर इन दैट केस ऑपरेशनल क्रेडिटर कैनॉट इनिशिएट दिस प्रोसेस, ठीक है। बट डिस्प्यूट में जो एडजुडिकेटिंग अथॉरिटी है उसका रोल कितना है, वो ये कहता है कि द ट्राइब्यूनल कैनॉट गो इनटू रोविंग इंक्वायरी इनटू द डिस्प्यूटेड क्लेम ऑफ द पार्टीज as the object of the code is to ensure reorganization and insolvency resolution of corporate persons, individuals in a time bound manner for maximization of value of assets। उसको कितना देखना है, ट्राइब्यूनल को इतना ही देखना है कि भाई ये सिर्फ कोई फीबल आर्गुमेंट तो नहीं है कि जस्ट फॉर द सेक ऑफ डिस्प्यूट यू हैव रेज्ड अ डिस्प्यूट, वैसा नहीं होना चाहिए, ठीक है। लेकिन आपको रोविंग इंक्वायरी भी नहीं करना है, आपको बहुत ज्यादा डिटेल में भी नहीं जाना है। आपको लगता है कि डिस्प्यूट है, जेन्युइन डिस्प्यूट है, तो बस देन एप्लीकेशन कैन नॉट बी एडमिटेड। लेकिन उसमें आपको बहुत ज्यादा डिटेल में नहीं जाना है, क्योंकि आपको ये डिटरमिन नहीं करना है कि डिस्प्यूट है नहीं है, क्या है, किस लेवल का डिस्प्यूट है। आपको सिर्फ ये देना, इट शुड नॉट बी ए मियर फ्रिवोलस आर्गुमेंट, इट शुड नॉट बी मियर ए प्लॉय टू डाइवर्ट द प्रोसेस, ये इतना ही देखना है बस। देन ऑन कॉर्पोरेट पर्सन, कॉर्पोरेट पर्सन और कॉर्पोरेट डेटा दोनों डिफरेंट है, दैट वी हैव सीन। तो नेशनल हाईवे अथॉरिटी ऑफ इंडिया इज अ स्टैट्यूटरी बॉडी which functions as an extended limb of the central government and performs government functions which obviously cannot be taken over by an RP, ठीक है, or by any other corporate body, nor can NHAI ultimately be wound up under the code, ठीक है। वो ही कहता है कि जो NHAI है ये एक स्टैट्यूटरी बॉडी है which functions as an extended arm of the central government, तो ये आईबीसी में नहीं आ सकती, ठीक है। फॉर ऑल दीज रीजंस इट इज नॉट पॉसिबल टू आइदर रीड इन और रीड डाउन द डेफिनेशन ऑफ कॉर्पोरेट पर्सन इन सेक्शन 3 सबसेक्शन 7 टू इंक्लूड एनएचएआई। तो एनएचएआई जो है ये कॉर्पोरेट पर्सन में नहीं आएगी, ठीक है। अब ये ना, मान लो गवर्नमेंट है, आप गवर्नमेंट को आईबीसी में ला सकते हो क्या? द आंसर इज नो, ठीक है। नेक्स्ट, there is no exemption provided under the Companies Act or the code from the insolvency proceedings with regard to a company which is substantially owned by the government। अब इसमें क्या है, इसमें उल्टा कहा, इसमें क्या कहा, इसमें इसमें ये कहा, जस्ट अ मिनट, कि ऐसी कोई एग्जम्पशन नहीं है, there is no exemption provided under the Companies Act or under the code from the insolvency proceedings with regard to a company which is substantially owned by the government। तो ऐसा नहीं है वो substantially owned by government है, वो नहीं ला सकते, तो दोनों सेपरेट कॉन्फ्लिक्टिंग जजमेंट्स हो गए, ठीक है। अंडर सेक्शन 3 सबसेक्शन 7 ऑफ द कोड कोऑपरेटिव सोसाइटीज आर नॉट कॉर्पोरेट पर्संस। अब कई बार क्वेश्चन उठता है कि क्या कोऑपरेटिव सोसाइटीज या ट्रस्ट पर whether they are covered under corporate person, the answer is no। ये कहाँ आएंगे? पार्ट 3 में आएंगे, ठीक है। जो सोसाइटीज हैं, कोऑपरेटिव सोसाइटीज हैं, ट्रस्ट्स हैं, ये सारे कहाँ पर आएंगे? पार्ट 3 में, ये नॉन कॉर्पोरेट पर्सन में आते हैं, ठीक है। नाउ लेट अस सी द डेफिनेशन ऑफ कॉर्पोरेट डेटा, सेक्शन 3 सबसेक्शन 8। ये भी हमने पढ़ ली। हमने क्या पढ़ा सेक्शन 3 सबसेक्शन 8 में? हमने ये पढ़ा था कि कॉर्पोरेट डेटर इज ए कॉर्पोरेट पर्सन हु ओज ए डेट, है ना। सो लक्ष्मीपत सुराना में क्या बोला? इफ ए कॉर्पोरेट पर्सन एक्सटेंड्स गारंटी फॉर द लोन ट्रांजेक्शन कंसर्निंग ए प्रिंसिपल बोरोवर नॉट बीइंग ए कॉर्पोरेट पर्सन, सपोज एक प्रोप्राइटरशिप फर्म है, ठीक है। प्रोप्राइटर ने लोन लिया और गारंटी किसने दे दी? कंपनी ने, ठीक है। तो अब क्वेश्चन ये है कि क्या वो पार्ट 2 में आ सकता है? इफ ए कॉर्पोरेट पर्सन एक्सटेंड्स गारंटी फॉर द लोन being taken by a non-corporate person, it would still be covered within the meaning of the expression corporate debtor. तो वो भी corporate debtor के अंदर आ जाएगा, ठीक है। क्योंकि क्या हो गया, हमने क्या किया कि वो पर्सनल गारंटर्स और कॉर्पोरेट डेटर्स पर भी एप्लीकेबल कर दी ना प्रोविजंस, तो वो कॉर्पोरेट पर्सन के अंदर कवर हो जाएगा, कॉर्पोरेट डेटर में कवर हो जाएगा, ठीक है। जिसने लोन लिया वो नॉन कॉर्पोरेट पर्सन है और जिसने गारंटी दी वो कॉर्पोरेट पर्सन, ठीक है, तो वो कॉर्पोरेट डेटर में कवर हो जाएगा। सेक्शन 3 सबसेक्शन 10 क्रेडिटर, the parties who have entered into agreement for purchase of flat or shop or any immovable property which contains a clause of assured or committed returns are financial creditors under the code. Sometimes you might have seen ads in the paper. कई बार आप पेपर में ऐड देखते हो ना, क्या कहता है कि भाई यू गिव अस मनी, वी विल गिव यू 12% और 18% इंटरेस्ट, ठीक है, टिल द टाइम यू आर गिवन पोजेशन। तो ये क्या है, दे आर फाइनेंशियल क्रेडिटर्स, बिकॉज वो जो बिल्डर है, बिल्डर क्या कर रहा है, बिल्डर उनकी मनी को ही यूटिलाइज कर रहा है। सो पार्टीज who have entered into an agreement for purchase of flat or shop or any immovable property which contains a clause of assured or committed returns are financial creditors। तो ये फाइनेंशियल क्रेडिटर्स में आते हैं, ठीक है। अब डिक्री होल्डर के बारे में क्या है, डिक्री होल्डर, यू नो डिक्री होल्डर क्या होता है, डिक्री होल्डर इज ए पर्सन who has approached the civil court and obtained a decree against a person। जिसके अगेंस्ट में डिक्री मिलती है उसको कहते हैं जजमेंट डेटर, और जिसके फेवर में डिक्री होती है उसको कहते हैं डिक्री होल्डर, ठीक है। अब ये जो डिक्री होल्डर है, ही इज कवर्ड अंडर द डेफिनेशन ऑफ क्रेडिटर, ठीक है, अंडर सेक्शन 3 सबसेक्शन 10। इट वुड नॉट फॉल विद इन द क्लास ऑफ फाइनेंशियल क्रेडिटर और ऑपरेशनल क्रेडिटर्स, एंड देयरफॉर ए डिक्री होल्डर cannot initiate CIRP against the CD with an objective to execute the decree। मतलब ये एक आदमी को पैसे नहीं मिले, वो कोर्ट में चला गया, उसके फेवर में डिक्री अवार्ड हो गई। नाउ द क्वेश्चन इज वेदर दैट पर्सन कैन इनिशिएट प्रोसीडिंग्स, द आंसर इज नो। उसको क्लेम मिलेगा, he will be entitled to file the claim, but he cannot file the petition as फाइनेंशियल और ऑपरेशनल क्रेडिटर। भाई ना वो हमने क्या पढ़ा, हमने पढ़ा कि कौन कौन लोग एप्लीकेशन फाइल कर सकते हैं, फाइनेंशियल क्रेडिटर, ऑपरेशनल क्रेडिटर्स और कॉर्पोरेट डेटर। तो ना वो फाइनेंशियल क्रेडिटर है, ना वो ऑपरेशनल क्रेडिटर, ना ही वो कॉर्पोरेट डेटर है, ठीक है। तो डिक्री होल्डर ना सेक्शन 7 ना 9 या 10 की एप्लीकेशन फाइल नहीं कर सकता, ठीक है। नेक्स्ट, टू इक्वेट द यूनिट होल्डर्स इन म्यूचुअल फंड्स with the creditors under the code will be unsound and incongruous। वो कहता है कि भाई जो म्यूचुअल फंड है, म्यूचुअल फंड आपने किसी कंपनी में म्यूचुअल फंड में अप्लाई कर दिया, तो क्या आप क्रेडिटर हो, द आंसर इज नो, ठीक है। तो कहता है ये क्रेडिटर नहीं है। डेट एंड डिफॉल्ट, डेट एंड डिफॉल्ट पर भी बहुत सारे केस लॉज हैं। सेक्शन 3, 11 एंड 12 क्या बोलता है, when the definitions of operational debt, debt and default are read together। हम तीन definitions को इकट्ठा पढ़ते हैं, किसको, operational debt, debt and default। It can be said that the definition of debt as defined under the code does not mean operational debt only, ठीक है, rather it includes a financial debt as well as a liability or obligation in respect of a claim which is due from any person, and default means non-payment of debt। But in order to trigger section 9, an OC is required to establish a default for non-payment of operational debt as defined under section 5 subsection 21 of the code, and if a person fails to establish that, they cannot initiate CIRP, ठीक है। तो इसमें बताया कि ऑपरेशनल डेट और डेट और डिफॉल्ट को आपको पढ़ना है। डेट में कौन से आते हैं, डेट में ऑपरेशनल डेट भी आएगा और फाइनेंशियल डेट भी आएगा। It is latently and patently clear that once the debt is converted into capital, it cannot be termed as financial debt, ठीक है। मान लीजिए आपने डिबेंचर्स इशू कर रखे हैं, आपने डिबेंचर्स को कन्वर्ट कर दिया इक्विटी में, तो क्या वो फाइनेंशियल डेट रहेगा, द आंसर इज नो, ठीक है। सो इफ द डेट इज कन्वर्टेड इनटू कैपिटल, इट कैन नॉट बी टर्म्ड एज फाइनेंशियल डेट, ठीक है। डेट इज डिस्प्यूटेड so long as the debt is due, that is payable unless interdicted by some law or has not yet become due in the sense that it is payable at some future date. ठीक है? It is only when this is proved to the satisfaction of the A that it may reject an application and not otherwise. ठीक है? वो ये कहता है कि debt is disputed so long as the debt is due, that is payable, unless interdicted by some law or has not yet become due in the sense that it is payable at some future date. तो सबसे पहले तो जो डिस्प्यूट है वो हमारे को इट हैज टू बी प्रूव टू द सेटिस्फैक्शन ऑफ द एडजुडिकेटिंग अथॉरिटी. So existence of an undisputed debt is sine qua non of initiating CIRP. ठीक है? If in terms of any agreement interest is payable to the OC or the FC, अब बात आती है कि डेट में क्या आएगा, इंटरेस्ट भी आएगा या प्रिंसिपल अमाउंट ही आएगा. दिस इज द क्वेश्चन. सो इट सेज इफ we have to see the terms of the agreement. If in terms of any agreement interest is payable to the OC or the FC, then the debt will include interest. Otherwise the principal amount is to be treated as debt, which is the liability in respect of the claim which can be made from the CD. ठीक है? तो आपको टर्म्स ऑफ एग्रीमेंट देखनी पड़ेंगी. अगर टर्म्स ऑफ एग्रीमेंट में इंटरेस्ट पेबल है तो इंटरेस्ट इंक्लूडेड होगा, अदरवाइज प्रिंसिपल अमाउंट ही डेट है. ठीक है? नेक्स्ट. Mere fact of debt being due and payable is not enough to justify the initiation of CIRP at the instance of the FC unless the default on the part of the CD is established. वो कहता है कि डेट ड्यू एंड पेएबल है, उसी से नहीं हो जाएगा, डिफॉल्ट भी होना जरूरी. ठीक है? मान लो कोई डेट ड्यू है और पेएबल भी है. ठीक है? तो आपको डिफॉल्ट भी एस्टेब्लिश करना है. ठीक है? और डिफॉल्ट इज डिफाइंड इन सेक्शन 3 सबसेक्शन 12 in very wide terms as non-payment of a debt once it becomes due and payable. तो डिफॉल्ट कहां डिफाइंड है? सेक्शन 3 सबसेक्शन 12 में. तो डिफॉल्ट इज डिफाइंड इन सेक्शन 3 सबसेक्शन 12 in very wide terms as non-payment of a debt once it becomes due and payable, which includes non-payment of even part thereof or an installment amount. So even if a part is due, so then also it is considered as default. The context of section 3 subsection 12 is actual non-payment by the CD when a debt has become due and payable. ठीक है? An amount not released to FC due to misunderstanding between the consortium of banks cannot be treated as default. ठीक है? The legislature was conscious regarding liabilities arising from a particular type of lease, and it made specific provision in section 58D to make it a financial debt. ठीक है? No such provision was made in respect of an operational debt. तो वो कहता है कि फाइनेंशियल लीज होनी चाहिए या कैपिटल लीज होनी चाहिए इन ऑर्डर टू क्वालिफाई एज ए फाइनेंशियल डेट. ठीक है? लेकिन ऑपरेशनल डेट में ऐसा कोई लीज वाला प्रोविजन नहीं है, क्योंकि ऑपरेटिंग लीज जो है, ऑपरेटिंग लीज को कवर नहीं करते फाइनेंशियल डेट पे. ठीक है? CIRP can be initiated against a CD which has defaulted in repaying the loan in the capacity of co-borrower or pledger, as the liability of borrower and co-borrower pledger is coextensive under the Indian Contract Act. ठीक है? तो वो कहता है कि CIRP can be initiated against a CD which has defaulted. ठीक है? डिफॉल्ट कौन करेगा? चाहे को बोरोवर ने किया हो या प्लेजर ने किया हो, क्योंकि लाइबिलिटी ऑफ बोरोवर एंड को बोरोवर या प्लेजर इज कोएक्सटेंसिव. It is beyond the purview of the A to venture into the question of the reason for the default and the intention behind the default as submitted by the CD, especially when the application is filed under section 7. तो सेक्शन 7 की जो फाइल एप्लीकेशन फाइल्ड है, आपको डिफॉल्ट के रीजंस में नहीं जाना है. डिफॉल्ट हो गया तो मतलब आपको एप्लीकेशन एडमिट कर लेनी है. ठीक है? नाउ सपोज शेयर परचेज ऑप्शन है. ठीक है? तो शेयर परचेज के केस में क्या होगा? शेयर परचेज विद एग्जिट ऑप्शन of inter alia annual put option cannot be considered as a debt which is disbursed against the consideration of the time value of money. ठीक है. Equity is not a debt, and as such, any contract for acquisition of shareholding in a company cannot result in the formation of a debt. ठीक है. Then section 3, subsection 23, person. A sole proprietary concern not being a person under section 3, subsection 23 of the code, and also when there is a pre-existing dispute cannot file application under section 9. ठीक है. अगर कोई सोल प्रोप्राइटरी कंसर्न है, ठीक है, ये जो है इट इज नॉट ए पर्सन अंडर सेक्शन 3 सबसेक्शन 23, एंड ऑल्सो व्हेन देयर इज अ प्री एग्जिस्टिंग डिस्प्यूट इट कैनॉट फाइल एन एप्लीकेशन अंडर सेक्शन 9. अच्छा, ट्रेड यूनियन is an entity established under statute and is therefore a person under section 3 subsection 23 of the code. इससे पहले हम क्या करते हैं, ये एक बार सेक्शन 3 सबसेक्शन 23 को भी रिविजिट कर लेते हैं, है ना, तब ये ज्यादा समझ में आएगी चीज. तो सेक्शन 3 सबसेक्शन 23 में क्या बोलता है, वो पर्सन की डेफिनेशन देता है. तो लेट अस सी द डेफिनेशन ऑफ पर्सन. तो पर्सन में क्या क्या इंक्लूडेड है. ये पर्सन सेक्शन 3 सबसेक्शन 23. So person includes individual, Hindu undivided family, company, trust, partnership, LLP, any other entity established under statute and includes a person resident outside India. ठीक है. तो सारे के सारे जो है वो लोग पर्सन में इंक्लूडेड है. अब मान लो को प्रोप्राइटरी कंसर्न है, ठीक है. अब प्रोप्राइटरी कंसर्न तो यहाँ लिखा नहीं, ठीक है ना. तो प्रोप्राइटरी कंसर्न क्या पर्सन है? द आंसर इज नो. ये वो कहना चाह रहा है. तो उस केस में क्या होगा, जो इंडिविजुअल होगा वो आ जाएगा पर्सन. ठीक है. सोल प्रोप्राइटरी कंसर्न not being a person under section 3 subsection 23 and also when there is a pre-existing dispute cannot file application under section 9. ठीक है. ट्रेड यूनियन जो है, ट्रेड यूनियन इज ए पर्सन अंडर सेक्शन 3 subsection 23. ठीक है. A proprietary concern does not fall within the purview of person as per section 3 to subsection 23 for the purpose of filing an application under section 9. Proprietary concern cannot sue or be sued unless it is represented by a proprietor. ठीक है. Another important definition is of secured creditor. Secured creditor पर हमारा केस लॉ भी है. ये है अपना स्टेट टैक्स ऑफिसर वर्सेस रेनबो पेपर्स. इसमें क्या कहा गया, देयर वाज अ कंपनी ऑफ गुजरात एंड दैट वाज रजिस्टर्ड अंडर गुजरात वैट एक्ट. नाउ गुजरात वैट एक्ट said that suppose there is a dealer, VAT dealer, and is not able to clear the VAT dues, then the government will have charge over its assets. That is what was contained in the Gujarat VAT Act. So now the question came whether this security interest could be created by operation of law, and Supreme Court said yes, it could be created even by operation of law. ठीक है. So it says that state tax officer does not come within the meaning of secured creditor as defined under section 3 subsection 30 read with section 3 subsection 31. So this was the judgment of NCLT which was reversed by Supreme Court, and Supreme Court here said that security interest could be created by operation of law also. ठीक है. So we can revise this thing here. ये NCLT का था और ये वाला आंसर सुप्रीम कोर्ट का नहीं है. एक्चुअली सुप्रीम कोर्ट ने उल्टा बोला था. तो सुप्रीम कोर्ट सेड दैट सिक्योरिटी इंटरेस्ट कुड बी क्रिएटेड बाय ऑपरेशन ऑफ लॉ. सिक्योरिटी इंटरेस्ट कुड बी क्रिएटेड बाय अब एक बार हम ना सिक्योरिटी इंटरेस्ट की डेफिनेशन भी देख लेते हैं बाय ऑपरेशन ऑफ लॉ. सो दिस इज व्हाट वाज सेड बाय सुप्रीम कोर्ट. तो एक बार हम जरा सिक्योरिटी इंटरेस्ट और सिक्योर्ड क्रेडिटर की डेफिनेशन को भी देख लेते हैं, वो भी इंपॉर्टेंट है. सिक्योर्ड क्रेडिटर. सिक्योर्ड क्रेडिटर क्या है? सिक्योर्ड क्रेडिटर मीन्स ए क्रेडिटर इन फेवर ऑफ होम सिक्योरिटी इंटरेस्ट इज क्रिएटेड. ठीक है. और सिक्योरिटी इंटरेस्ट क्या है? सिक्योरिटी इंटरेस्ट मीन्स राइट, टाइटल और इंटरेस्ट और ए क्लेम टू प्रॉपर्टी क्रिएटेड इन फेवर ऑफ और provided for a secured creditor by a transaction which secures payment or performance of an obligation and includes mortgage, charge, hypothecation, assignment, and encumbrance or any other agreement or arrangement securing payment or performance of any obligation of any person. Let us understand it by way of an example. You are a company, you ask another company to supply you some components. That company says, what is the guarantee that you will take these components from me? You may refuse to take it tomorrow. And because I am manufacturing it for you only, so they may not be saleable in the market. So I may incur a loss. So what is the guarantee? Now you say that, okay, I give you, say, a charge against my properties. So that is creation of security interest. So by creating the security interest, what you have secured is, you have secured the performance of an obligation. ठीक है. It could be to secure payment or it could be to secure performance of an obligation. Performance of an obligation किस केस में आएगा? Normally ऑपरेशनल क्रेडिटर्स के केस में. और सिक्योरिंग पेमेंट किस केस में आएगा? फाइनेंशियल डेट. ठीक है. सो दिस सिक्योरिटी इंटरेस्ट कुड बी इन रिस्पेक्ट ऑफ फाइनेंशियल क्रेडिटर्स, इट कुड बी इन रिस्पेक्ट ऑफ ऑपरेशनल क्रेडिटर्स ऑल्सो. ठीक है. ये मतलब. अब चलिए एक बार दोबारा से अपना सेक्शन वाइज जूरिस्प्रूडेंस. एक इसमें और इंपॉर्टेंट डेफिनेशन है, वो है वर्कमैन की. वर्कमैन क्या बोलता है? वर्कमैन शैल हैव द सेम मीनिंग as assigned to any clause S of section 2 of the Industrial Disputes Act. तो वर्कमैन के लिए कहां जाना है आपको? क्लॉज S ऑफ सेक्शन 2. तो एक बार क्लॉज S ऑफ सेक्शन 2 भी देख लेते हैं. तो क्लॉज S ऑफ सेक्शन 2 क्या है बेसिकली? एक मिनट. क्लॉज S ऑफ सेक्शन 2 ऑफ इंडस्ट्रियल डिस्प्यूट्स एक्ट. ये क्या कहती है? ये है क्लॉज S. मैं थोड़ा बड़ा कर देता हूं उसको. मैं एक बार शेयर करता हूँ. ये क्लॉज S क्या है? ये है आपकी क्लॉज S. ठीक है जी. अब नजर आ रही होगी आपको। क्लॉज हैज वर्कमैन। व्हाई दिस डेफिनेशन ऑफ वर्कमैन इज इंपॉर्टेंट? देखो ऐसा है, आईबीसी में क्या है, बिकॉज डिफरेंट प्रायोरिटीज है ऑफ पेमेंट, वर्कर्स की अलग है, एम्प्लॉयज के लिए अलग है, ठीक है। सो दैट इज वाई अंडरस्टैंडिंग दिस डेफिनेशन इज इंपॉर्टेंट। सो वर्कमैन मीन्स एनी पर्सन इंक्लूडिंग एन अप्रेंटिस एम्प्लॉयड इन एनी इंडस्ट्री टू डू एनी मैनुअल, अनस्किल्ड, स्किल्ड, टेक्निकल, ऑपरेशनल, क्लerical और सुपरवाइजरी वर्क for hire or reward, whether the terms of employment be express or implied, and for the purpose of any proceeding under this act in relation to an industrial dispute, includes any such person who has been dismissed, discharged or retrenched. लेकिन कौन इंक्लूडेड नहीं है? जिस पर एयरफोर्स एक्ट लगता है, या कोई पुलिस सर्विस में एम्प्लॉयड है, या एज एन ऑफिसर और अदर एम्प्लॉय ऑफ ए प्रिजन, ठीक है, या फिर मैनेजरल या एडमिनिस्ट्रेटिव कैपेसिटी में एम्प्लॉयड है, या who being employed in a supervisory capacity draws wages exceeding 10,000 rupees per month, ठीक है, or exercises either by the nature of the duties attached to the office or by reasons of the power vested in him functions mainly of a managerial nature। तो उस केस में क्या होगा, ये आपका वर्कमैन में नहीं आएगा, ठीक है। ये मतलब कई बार इस पर क्वेश्चन भी पूछ लेता है आपका, कि वो कहता है जी वर्कमैन में कौन इंक्लूडेड है और कौन इंक्लूडेड नहीं है। ये कॉपी टेक्स्ट करके और मैं आपको ये चैट बॉक्स में डाल देता हूँ। ₹10,000 इतना ही कर देते हैं, ठीक है जी। तो ये मैंने चैट बॉक्स में डाल दी डेफिनेशन। तो ये भी हो गया आपका, वर्कमैन की डेफिनेशन भी हो गई। अब हम काम करते हैं दोबारा से अपना, वही जूरिस्प्रूडेंस पर चलते हैं, ठीक है। नाउ सेक्शन 4। सेक्शन 4 क्या कहता है? सेक्शन 4 टॉक्स ऑफ एप्लीकेशन ऑफ पार्ट 2। अब इसमें क्या हुआ था, द अनाउंसमेंट ऑफ थ्रेशोल्ड by notification dated 24th March issued by MCA is prospective in nature। ये कोविड पीरियड में क्या हुआ था, ये 1 लाख टू 1 करोड़ हो गई थी लिमिट, ठीक है। अब क्वेश्चन ये हुआ कि भाई ये जो 1 लाख टू 1 करोड़ हुई है, ये क्या प्रोस्पेक्टिव है या रिट्रोस्पेक्टिव है? तो इस केस में ये कहा कि द अनाउंसमेंट ऑफ थ्रेशोल्ड वाइड नोटिफिकेशन डेटेड 24th March issued by Ministry of Corporate Affairs is prospective in nature and it would not apply to pending applications filed prior to the issuance of the said notification। अब क्वेश्चन क्या आता है, मान लो कोई एप्लीकेशन पहले से फाइल्ड है ना, पहले तो लिमिट 1 लाख थी, बाद में हो गई 1 करोड़, तो जो एप्लीकेशन पहले फाइल होगी उसमें उन पर वो लिमिट अप्लाई होगी या नहीं होगी, विच आर नॉट येट डिसाइडेड। तो उन्होंने कहा इट इज प्रोस्पेक्टिव इन नेचर एंड इट वुड नॉट अप्लाई टू पेंडिंग एप्लीकेशंस फाइल्ड प्रायर टू द इश्यूएंस ऑफ द सेड नोटिफिकेशन, ठीक है। दूसरा केस क्या आया, द नोटिफिकेशन डेटेड 24th March whereby the minimum amount of default was specified as 1 crore is prospective in nature and not a retrospective। एक और केस आया, द लॉ इज वेरी क्लियर दैट इट इज इनफ इफ अंडर सेक्शन 4 द अनपेड डेट इज मोर देन द थ्रेशोल्ड वैल्यू ऑफ 1 लाख फॉर एक्सेप्टेंस ऑफ एप्लीकेशन अंडर सेक्शन 9 ऑफ द कोड। ये पुराना है उससे पहले, ठीक है। वेयर द डिफॉल्ट इज अकर्ड, अब इसमें देखो इंपॉर्टेंट है, डिफॉल्ट कब हुआ? डिफॉल्ट हो गया प्रायर टू द इश्यूएंस ऑफ नोटिफिकेशन, ठीक है, dated 24th March and demand notice was also delivered prior to that notification but the application has been filed after 24th March। एक ये भी केस आ गए ना, कुछ कुछ केसेस ऐसे आ गए जिसमें डिफॉल्ट तो पहले हो गया, आपने डिमांड नोटिस भी डिलीवर कर दिया, लेकिन एप्लीकेशन फाइल नहीं हुआ। तो उस केस में क्या होगा, उसमें ये कहा कि जो पुरानी वाली लिमिट है वही एप्लीकेबल होगी 1 लाख की। ठीक है, क्लियर है। नेक्स्ट, द इंटरेस्ट अमाउंट कैनॉट बी क्लब्ड विद द प्रिंसिपल अमाउंट ऑफ डेट टू अराइव एट द मिनिमम थ्रेशोल्ड ऑफ 1 करोड़। अब क्वेश्चन ये है कि 1 करोड़ में क्या इंटरेस्ट भी इंक्लूड करना है? वो ही कहता है कि भाई आप पहले टर्म्स को देखो, जो टर्म्स ऑफ एग्रीमेंट है। ठीक है, वो कहता है इंटरेस्ट अमाउंट कैनॉट बी क्लब्ड विद द प्रिंसिपल फॉर एन एप्लीकेशन फाइल्ड अंडर सेक्शन 9 ऑफ द कोड। तो ऑपरेशनल डेट में आपको क्या इंक्लूड करना है? प्रिंसिपल अमाउंट ही इंक्लूड करना है। द थ्रेशोल्ड हैज टू बी एप्लीकेबल ऑन द डेट ऑफ फाइलिंग ऑफ द एप्लीकेशन। ठीक है, नेक्स्ट केस बोला इसमें ठाकरान वेब इनोवेशंस में, फ्रॉम द डेट ऑफ अमेंडमेंट पार्ट 2 of the code can apply only to matters relating to insolvency and liquidation of CD where the minimum amount of default is 1 crore. The application of Part 2 itself is taken away with effect from 24th March as far as default less than 1 crore are concerned. And as no application can be filed after 24th March regarding an amount where the default is less than 1 crore. ठीक है, another उसमें कुछ केस लॉज है ऑन कॉर्पोरेट गारंटर। सो एज यू नो देयर कुड बी टू टाइप्स ऑफ गारंटर्स। कुछ होंगे कॉर्पोरेट गारंटर, कुछ होंगे पर्सनल गारंटर। जो पर्सनल गारंटर हैं वो कहाँ आ रहे हैं? आपके पार्ट 3 में आ रहे हैं, इंडिविजुअल्स और पार्टनरशिप फर्म्स। मतलब लोन के लिए गारंटी कौन दे सकता है? कंपनी ने भी दे सकती है या फिर इंडिविजुअल या पार्टनरशिप फर्म ने दी हो। अगर कंपनी ने गारंटी दी है तो वो कॉर्पोरेट गारंटर में आएगा, अगर इंडिविजुअल या पार्टनरशिप फर्म ने दी है तो वो फिर पर्सनल गारंटर। ठीक है, नाउ लेट अस सी दी provisions regarding corporate guarantor. If CIRP has been initiated against the CD, the insolvency and bankruptcy process against the personal guarantor can be filed under section 60 subsection 2 before the same NCLT. क्योंकि हमने क्या पढ़ा? हमने ये पढ़ा कि जो इंडिविजुअल्स है या जो पार्टनरशिप फर्म्स है उनके लिए एडजुडिकेटिंग अथॉरिटी कौन है? DRT है। बट इस केस में क्या हो रहा है? लोन लिया है कंपनी ने और गारंटी दी है पर्सनल गारंटर ने। तो अब बात यह है कि ये पर्सनल गारंटर के अगेंस्ट में जो प्रोसीडिंग है वो एनसीएलटी में जाएंगी या डीआरटी में जाएंगी। तो इन्होंने ये कहा कि सेक्शन 60 सबसेक्शन 2 क्लियर है। तो सेक्शन 60 सबसेक्शन 2 बोलता है कि द प्रोसीडिंग्स कैन बी फाइल्ड बिफोर द सेम एनसीएलटी एंड नॉट बिफोर डीआरटी। तो सेक्शन 178 भी कहता है, सेक्शन 178 भी जुरिस्डिक्शन से डील करता है ऑफ इंडिविजुअल्स एंड पार्टनरशिप फर्म्स, और सेक्शन 178 बोलता है कि इट इज सब्जेक्ट टू सेक्शन 60 सबसेक्शन 2। ठीक है, नेक्स्ट है विदाउट इनिशिएटिंग सीआईआरपी अगेंस्ट द प्रिंसिपल बोरोवर इट इज ओपन टू द एफसी टू इनिशिएट सीआईआरपी अंडर सेक्शन 7 अगेंस्ट कॉर्पोरेट गारंटर्स एज द क्रेडिटर इज आल्सो द एफसी qua कॉर्पोरेट गारंटर। तो ऑप्शन किसके पास है? ऑप्शन क्रेडिटर के पास है, चाहे वो कॉर्पोरेट डेटर के अगेंस्ट में प्रोसीड करे या कॉर्पोरेट गारंटर के अगेंस्ट में प्रोसीड करे। ठीक है, लायबिलिटीज कोएक्सटेंसिव। द प्रिंसिपल डेटर इज डिस्चार्ज अंडर द कोड नॉट ऑन द इंस्टेंस ऑफ ए क्रेडिटर बट ड्यू टू ऑपरेशन ऑफ लॉ, दैट इज अप्रूवल ऑफ द रेजोल्यूशन प्लान। Hence, the guarantor is not discharged of its liability merely because the creditor consented to a resolution plan of the principal debtor. ठीक है, let us understand it by way of an example. Bank has given loan of say 100 crores. 80 crore was realized because of this resolution plan, but 20 crore is still outstanding. Then whether for that 20 crores whether it can proceed against the guarantor, the answer is yes. ठीक है, वो ही कहता है कि the principal debtor is discharged not on the instance of a creditor but due to operation of law. So guarantor is not discharged of its liability. ठीक है, next is the corporate guarantees given by the CD can be invoked only in the end of a default on the part of the borrower. अगर मान लो गारंटी दी है किसी ने कॉर्पोरेट गारंटी, तो उसको इन्वोक कब कर सकते हो? जब डिफॉल्ट होगा। अगर डिफॉल्ट नहीं हुआ तो देन यू कैन नॉट इन्वोक द गारंटी। दिस इज द मीनिंग। ठीक है, नेचुरली भाई डिफॉल्ट नहीं होगा तो आप इनिशिएट ही नहीं कर सकते प्रोसेस। नेक्स्ट इज इट मेक्स नो डिफरेंस एज टू वेदर द कॉर्पोरेट पर्सन स्टूड एज गारंटर टू एन इंडिविजुअल और ए कॉर्पोरेट पर्सन। ठीक है भाई, गारंटी आपने इंडिविजुअल को दी है या कॉर्पोरेट पर्सन को दी है, ठीक है, इससे कोई फर्क नहीं पड़ता। and as long as the obligation in respect of a claim is due from a corporate person falling within the definition of financial debt, then it is obvious that the creditor can proceed under section 7 of the code against such corporate person. ठीक है, मतलब गारंटर कॉर्पोरेट पर्सन है, कोई जरूरी नहीं है कि जो लोन लिया है जिसने वो भी कॉर्पोरेट पर्सन, वो इंडिविजुअल भी हो सकता है. ठीक है, नेक्स्ट. The code is at a nascent stage, and it is better that the interpretation of the provisions of the is taken up by the SC to avoid any confusion and to authoritatively settle the law. It directed that no further petitions involving the challenge to notification dated November 15, 2019, which brought into force certain provisions relating to personal guarantors to CD shall be entertained by any High Court. मतलब क्या हुआ कि जब ये पर्सनल गारंटर टू कॉर्पोरेट डेटर को अलग से नोटिफाई किया तो बहुत सारी पिटीशंस फाइल की गई. उसमें क्या कहा गया कि भाई यू हैव पिक एंड चूज कर रहे हो आप तो, क्योंकि आपने क्या किया कि जो इंडिविजुअल है जिसने खुद लोन लिया है उसके अगेंस्ट तो आप प्रोसीड नहीं कर सकते. ठीक है, लेकिन अगर इंडिविजुअल ने गारंटी दी है तो उसके अगेंस्ट में प्रोसीड कर सकते हैं. बट तो सुप्रीम कोर्ट ने कहा कि भाई ये सारे मैटर्स कौन देखेगा, सुप्रीम कोर्ट देखेगा. ठीक. नेक्स्ट इज नाइदर सेक्शन 14 nor section 31 of the code place any fetters on the bank or financial institution from initiation and continuation of proceedings against the guarantor. Section 14 talks of moratorium. तो सेक्शन 14 में मोरेटोरियम लग जाता है. मोरेटोरियम में क्या होता है कि यू कैनॉट प्रोसीड इन रिस्पेक्ट ऑफ एनी सूट और प्रोसीडिंग. ठीक है, तो ये कहता है कि नाइदर सेक्शन 14 नॉर सेक्शन 31 place any fetters on the bank or financial institution from initiation and continuation of proceedings against the guarantor for recovering of their dues. The liability of the principal borrower and guarantor remain coextensive, and a bank or financial institution is entitled to initiate proceedings against the personal guarantor under the SURFACI Act during the continuation of the CIRP against the principal borrower. ठीक है, तो गारंटर के अगेंस्ट में प्रोसीडिंग चल सकती है. CIRP कैन बी प्रोसीडेड अगेंस्ट द प्रिंसिपल बोरोवर एज वेल एज द गारंटर, दोनों के अगेंस्ट में भी चल सकती है. डिस्प्यूट के बारे में क्या बोला, सेक्शन 5 सबसेक्शन 6, एनी ऑब्जर्वेशन with regard to individual officer if made by a court of law or in any communication made by the operational creditor, the same cannot be treated to be an existence of dispute. ठीक है, अगर कोर्ट ने कोई ऑफिसर के अगेंस्ट में कोई ऑब्जर्वेशन दी है तो ये डिस्प्यूट नहीं माना जा सकता. ठीक, ये सबसे इंपॉर्टेंट सेक्शन है मोबिलॉक्स वाला. इट इज इन योर सिलेबस ऑल्सो. तो मोबिलॉक्स में क्या कहा, द टेस्ट ऑफ एग्जिस्टेंस ऑफ ए डिस्प्यूट इज वेदर द कॉर्पोरेट डेटर हैज रेज्ड ए प्लॉसिबल कंटेंशन रिक्वायरिंग फर्दर इन्वेस्टिगेशन which is not a patently feeble legal argument or any assertion of facts unsupported by evidence. Whether the defense is not spurious, mere bluster, plainly frivolous, or vexatious, a dispute, if it truly exists in fact between the parties, which may or may not ultimately succeed. वो ये कहता है कि बेसिकली आपको देखना क्या है डिस्प्यूट में, ये देखना चाहिए कि भाई ऐसा तो नहीं कि कोई फीबल लीगल आर्गूमेंट है, ऐसे कोई झूठ मूठ का आर्गूमेंट आपने कर दिया. ठीक है, या कोई ऐसा यू आर असर्टिंग सम फैक्ट्स विच आर अनसपोर्टेड बाय एविडेंस. ठीक है, तो ये देखना, इट शुड नॉट बी मियरली फ्रिवोलस, इट शुड नॉट बी मियर ब्लस्टर, प्लेनली फ्रिवोलस और वेक्सेशियस. ठीक है, डिस्प्यूट होना चाहिए, अल्टीमेटली सक्सीड होगा नहीं होगा वो एक अलग बात है. ठीक, द डिस्प्यूट शुड नॉट बी ए मियर वाइवाश एंड अटेम्प्ट टू derail the proceedings under section 8 and 9 of the code. ऐसा नहीं हो सकता कि भाई आप झूठ मूठ का ही कोई डिस्प्यूट रेज कर दो, कह दो जी हमारा डिस्प्यूट एग्जिस्ट करता. ठीक है, आईवाश नहीं होना चाहिए. A unilateral transfer of liability does not constitute a dispute within the meaning of section 5 subsection 6, and an interstate dispute between two groups of shareholders of the CD does not constitute a dispute in reference to OCs. मतलब अगर मान लो आपने कोई लाइबिलिटी ट्रांसफर कर दी, यूनिलेटरली ट्रांसफर कर दी, तो ये डिस्प्यूट नहीं है। ठीक है। या मान लो देयर इज ए डिस्प्यूट बिटवीन टू ग्रुप्स ऑफ शेयर होल्डर्स, तो वो भी डिस्प्यूट में नहीं आएगा। The dispute under section 5 subsection 6 of the code must be between the CD and the OCs. Dispute किसके बीच में होना चाहिए? CD और OCs के बीच में। ठीक है। नेक्स्ट है, on the existence of a dispute, it was observed that section 5 subsection 6 is an inclusive provision. जब ये बैंक्रप्सी लॉ रिफॉर्म्स कमेटी थी ना, बीएलआरसी में कंक्लूसिव डेफिनेशन थी, वहां क्या लिखा था? डिस्प्यूट मींस। लेकिन जब कोड बनाया तो कोड बनाते टाइम इसको कर दिया इंक्लूड्स, तो इंक्लूसिव डेफिनेशन कर दिया। तो on the existence of a dispute, it was observed that section 5 subsection 6 is an inclusive provision and does not confine the A from considering the existence of a dispute from a broader angle. Therefore, dispute in terms of section 8 to A of the code shall not be limited to instances specified in the definition section 5 subsection 6. Section 5 subsection 6 में हमने पढ़ा definition of dispute, क्या पढ़ा उसमें? तीन बातें, क्या क्या लिखी? रिप्रेजेंटेशन ऑफ वारंटी, डिस्प्यूट रिगार्डिंग द एग्जिस्टेंस ऑफ अमाउंट ऑफ डेट, है ना? तो वो तीन बातें उसमें लिखी हुई हैं। वो ही कहता है कि इसके अलावा भी चीजें हो सकती हैं, बिकॉज इट्स ए इंक्लूसिव डेफिनेशन। फाइनेंशियल क्राइटर क्या कहता है? mere invocation of pledge of shares will not result in automatic conversion of debt into equity and repayment of debt. ठीक है। मतलब ये है कि अगर एक आदमी ने अपने शेयर्स प्लेज कर रखे हैं, ठीक है, आपने वो शेयर्स इन्वोक कर लिए, आपने वो प्लेज को इन्वोक कर लिया, क्योंकि एक आदमी ने क्या किया? शेयर्स दे दिए बैंक को और उसके अगेंस्ट में लोन ले लिया। अब वो पैसे नहीं दे रहा, बैंक वो अपना प्लेज इन्वोक कर देता है। तो ये है कि इट विल नॉट रिजल्ट इन ऑटोमेटिक कन्वर्जन ऑफ डेट इनटू इक्विटी एंड रीपेमेंट ऑफ डेट। ठीक है। मतलब ये कि वो डेट इक्विटी में कन्वर्ट नहीं हो जाएगा। एक आदमी ने शेयर्स दे करके शेयर्स अपने प्लेज कर दिए और कंपनी से बैंक से लोन ले लिया, तो वो तो डेट ही है ना, वो इक्विटी तो नहीं है। ठीक है। The assignee of the debt is also entitled to file application and such assignee steps into the shoes of the financial creditor. ठीक है। The grouping of FCs in accordance with the amount of security holding is not discriminatory. अच्छा, what are the essential criteria for this FCs? पहला, a person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred. The debt along with interest, if any, is disbursed against the consideration for the time value of money and includes any one or more of the disbursed as mentioned in clause A to I of subsection 8 of section 5. ठीक है। ये जो अलॉटीज हैं या होम बायर्स है, दे आर इंक्लूडेड इन द मेन प्रोविजन with effect from the inception of the code. ठीक है। अच्छा, मान लीजिए कोई रिकरिंग इन्वेस्टमेंट प्लान है। In a recurring investment plan wherein the CD failed in its commitment to offer the allotment of plots of land as promised by it or pay the assured returns or repay the sums collected by it along with interest on the maturity of the schemes, the investor's position is that of a FC. ठीक है। मतलब ये है, एक बिल्डर ने मान लीजिए लोगों से पैसे ले लिए कि भाई आप जो है पीरियोडिकली इन्वेस्टमेंट करते रहो, रिकरिंग इन्वेस्टमेंट प्लान दे दिया। अब वो ना तो प्लॉट दे पा रहा, ना उनके पैसे दे पा रहा। ठीक है। तो जो इन्वेस्टर है वो क्या है? वो एफसी है। ठीक है। नेक्स्ट केस है, the SC reiterated that a person having only security interest over the assets of the CD, even if falling within the description of secured creditor by virtue of collateral security extended by the CD, would not be covered by the definition of financial creditor under the code. It held that the CD in the matter has only extended security through pledge of shares and there was no liability to repay the loan taken by the borrower on the CD. Therefore, the creditor in such a case will at best be secured creditor qua CD and not the FC qua CD. अच्छा, कई बार क्या होता है, ट्राइपार्टाइट एग्रीमेंट हो जाता है, ठीक है। बिल्डर ने फ्लैट लिया, बिल्डर से फ्लैट लिया, एक इंडिविजुअल है, और उसने बैंक से लोन ले लिया। अब ये जो बैंक की क्या पोजीशन है, सो बैंक्स और फाइनेंशियल इंस्टीट्यूशंस विच हैव एडवांस लोन्स टू होम बायर्स, दे कैन नॉट बी कंसिडर्ड एज एफसी। तो क्या वो बैंक भी एफसी बन जाएगा? द आंसर इज नो, ठीक है। एंड इंक्लूडेड इन सीओसी स्पेसिफिकली इन द लाइट ऑफ द फैक्ट दैट द लाइबिलिटी टू रीपे द होम लोन इज ऑन द इंडिविजुअल होम बायर। तो वो जो इंडिविजुअल होम बायर है वो तो उसमें आएगा फाइनेंशियल कैरेक्टर में, लेकिन बैंक वो नहीं आएगा, ठीक है। फाइनेंशियल डेट। अब फाइनेंशियल डेट में देखो क्या होता है, कई बार ना जॉइंट डेवलपमेंट एग्रीमेंट हो जाता है। एक के पास लैंड है, दूसरे के पास कंस्ट्रक्शन की कैपेबिलिटी है, वो आपस में एग्रीमेंट कर लेते हैं, ठीक है। कि भाई हम मान लो आपस में क्या करेंगे, एक प्लॉट ऑफ लैंड है, एक आदमी के पास लैंड है, दूसरा डेवलपर है, वो जॉइंट डेवलपमेंट एग्रीमेंट साइन कर लेते हैं। अब क्वेश्चन ये है कि अब जो आदमी वो लैंड डेवलप कर रहा है, क्या वो फाइनेंशियल क्रेडिटर है? द आंसर इज नो, इज ए ऑपरेशनल क्रेडिटर, ठीक है। सो जॉइंट डेवलपमेंट एग्रीमेंट एंटर्ड इज ए कॉन्ट्रैक्ट ऑफ रेसिप्रोकल राइट्स एंड ऑब्लिगेशंस। बोथ पार्टीज आर एडमिटेडली जॉइंट डेवलपमेंट पार्टनर्स, ये तो पार्टनर्स हो गए, who entered into a consortium of sorts for developing an integrated township, and for any breach of terms of contract, section 7 application is not maintainable as the amount cannot be construed as financial debt, ठीक है। अब pledge of shares से क्या होगा? Pledge of shares would not fall within the concept of guarantee and indemnity so as to bring it within the definition of financial debt. The payment received for shares duly issued to a third party at the request of the payee, as evident from official records, would not be a debt. तो फाइनेंशियल डेट क्वालिफाई करने के लिए क्या होना चाहिए, उसमें कोई इक्विटी का एलिमेंट नहीं होना चाहिए। अच्छा, मान लीजिए किसी प्रमोटर ने कोई कंपनी दी है, तो क्या होगा वो? इट इज मैनिफेस्टली क्लियर दैट मनी एडवांस्ड बाय ए प्रमोटर डायरेक्टर और ए शेयर होल्डर ऑफ द सीडी एज अ स्टेक होल्डर टू improve financial health of the company and boost its economic prospects would have the commercial effect of borrowing on the part of the CD, notwithstanding the fact that no provision is made for interest thereon। मतलब प्रमोटर ने मान लो कोई कंपनी कंपनी को पैसा दिया, तो क्या वो फाइनेंशियल डेट में आएगा? द आंसर इज यस। हो सकता है उसमें कोई इंटरेस्ट का कोई प्रोविजन नहीं हो, बट स्टिल इट विल बी कंसिडर्ड एज फाइनेंशियल डेट, ठीक है। रियल एस्टेट प्रोजेक्ट्स में मनी रेज फ्रॉम द मोलॉटी, अलॉटी इज द कंसिडरेशन फॉर द टाइम वैल्यू ऑफ मनी, तो ये होम बायर में आ रही है। अच्छा, इंटर कॉर्पोरेट डिपॉजिट्स में क्या होगा? इफ इंटर कॉर्पोरेट डिपॉजिट इज मेड फॉर अ सर्टेन पीरियड which was to be paid back with interest, then such transaction will fall within the definition of financial debt। तो ये आप देख लीजिएगा, है ना, यू कैन गो थ्रू दीज। तो उससे क्या होगा, आपको ना थोड़ा सा इसमें और क्लैरिटी आ जाएगी डेफिनेशंस पार्ट में, ठीक है। इन द नेक्स्ट क्लास वी विल गो फ्रॉम सेक्शन 7। तो अभी कल और परसों तो कोई क्लास नहीं है, अभी नेक्स्ट क्लास होगी हमारी ट्यूसडे को, ठीक है। एंड देन वील स्टार्ट विद सेक्शन 7। इफ यू हैव एनी क्वेश्चंस यू कैन आस्क।